Thanks for having me. I know the experience and what it's like in terms of having the first oral argument, one of probably many to come, and a lot of you have some apprehension about the process. Some of you think you know what you're doing, and some of you are probably confused about what you need to do. And what I'm going to do today is give you the secrets and the tricks that win moot court arguments, that guarantee that when you walk out of the room, you will feel good no matter what happens in that room. And there are techniques, secrets, which have been shared with, I probably lectured to 10,000 people over my tenure. I've done moot court problems, I've argued moot court things, I've judged the competitions all over the country, and done lots of different things to get a good education on what are the things that work and don't work, what are the things that score points in terms of either advancing or performing well and feeling like you held your own in what will be a typically Socratic-like, event, for lack of a better phraseology. And to understand sort of the oral argument, think more about how you convince someone about anything. And what motivates people. It's interesting, I'm reminded of the story of the Jewish man who tells his son the secret to life. He says, son, if you want to get ahead in life, do well in math. If you do well in math, you'll be a superstar. He sends a Jewish kid off to school. The kid comes back with his first test a week later, 70. Dad says, son, are you not listening to me? If you don't do well in your next math test, I'm going to send you to Catholic school. He sends the Jewish kid off. The kid comes back. About a week later, his next test, 63. Dad says, that's it. I'm sending you to Catholic school. 2 weeks later, the kid's Catholic school. He comes back, first test, 100. Dad says, what's the secret? He says, Dad, first day I walked into class, looked up, saw that guy nailed to the plus sign, said they're serious about math. You never know what motivates people, but understanding what motivates people and understanding who your audience is going to determine how you perform. If you think about it in your personal relationships and life, how do you deal with difficult situations? How do you address people? How do you convince them of certain things that may be difficult to convince them of? How do you explain certain things? How do you persuasively get where you need to go? In order to do that, you have to understand and have a flow. You have to understand what the possibilities are that might be out there. What are the questions you might be asked? What are the challenges that you might face? What are the things and ways that somebody can defeat you? And how do I plan to answer those? If you walk in and you have that preparation, you'll be a superstar. I remember when I was national counselor for a multi-billion-dollar company, and I did big cases, and I would travel all over the country and try these cases on very short notice, multi-week trials in these different jurisdictions, and I'd always be against Smith, of Smith, Jones & Jones, the 800-person law firm, and he would bring all of his friends and uncles and lawyers and people in the room so they could see him defeat and destroy the lawyer who came in from the other side. And they'd be working on the case for 3 years, I'd be working on the case for 6 weeks, because I'd get a call from this billion-dollar company and saying, we have this law firm, and they're not doing a good enough job, so we need you to come in. And I'd bring in this war team, and we'd work 24 hours a day, 7 days a week. We'd learn everything there is to know about everything. And then we'd walk into the courtroom, and in one case in particular, I was in Oklahoma, and I had a case where the first time I met the judge is the day of trial. Not usually good, okay? So how did I learn about that judge ahead of time? So what I did is I studied the judge. Now let's put a little hold on that. Now during this time, the other guy is best friends with the judge. It's the chief judge. He goes to church with her. They're talking about the last, what the preacher said last week and how things are going. I mean, but she's not, the last word didn't disqualify her, so she's up there. My first day is going to be in front of her at the trial. So what I did is I sent people in to watch her on every single hearing she did for 4 weeks. And what happened is that she used a rule book. And she would use this rule book, and she used it so much that she started fraying the pages. And she had cute pink little tabs for certain things, and yellow tabs meant something else, and there was a green tab on that, and if you're in law school, you use all different color highlighters, and she had certain pages, and she loved page 84. That was like her favorite page. And a lot of times she would say, I'll turn your directive to page 84, which is such a preeminent rule 1.742, and it says blah, 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 blah. Fast forward, first day of trial, I walk in, I'm in front of her. We've got a day's worth of motions to argue about evidence that's going to come in before we start this multi-week trial. Hi, my name is Scott Major. I'm here on behalf of the defendants in this case. And as I say that, I reach down and pull up my rule book. When I pull up my rule book, it is framed in the same way hers is. It has the same yellow and pink and green tabs. And I said, you know, I'm new to this jurisdiction, but I got to tell you, page 84, that rule is it. That woman's eyes were this big. Okay? Fast forward, I win the trial, beat the God of gods, that no one could bring me the Wicked Witch of the West. The biggest guy there is. I bring him. When the trial's done and the jury's departed, she gets down off her bench. She walks past her friend and comes up to me and says, how did I do? I heard you're some national lawyer. Can you give me some constructive criticism on how I handled that? Now, what does that tell you? That tells you if you understand behavior, you understand the human condition, you understand the way the tendency of somebody is to act or what they're going to say, then you're going to succeed. I used to tell people when I taught law school, I would say, I'll give you two options. Option number one, we're going to have a quiz tomorrow. I'll give you the answers to the test. Option number two, we're going to have a quiz tomorrow, and I won't give you the answers to the test. Which would you prefer? Now, obviously, everybody wants the answers to the test. So the whole key is, what questions might they ask you? How do you capture the essence of what this HIPAA violation is about, how the Fourth Amendment encompasses it, and whose side is right, and whether you're going to be arguing on one side or the other, and how do you capture and display that in an emotional way, in a dramatic way, but not a melodramatic way? How do you do that? And how do you do that in the context of preparing so that when you walk into that room, you fear nothing? Now, to go back to my original story in that Oklahoma case, one of the most interesting things in the world was that when I walked in the room, remember, Smith is there, okay? The huge law firm, he's been working on the case 3 years, I've been on the case 6 weeks. What I knew to be true were two things. Number one, he was either thinking, this guy is a lunatic. Only a lunatic would come in with 6 weeks' notice and try a case against me, Jones, of Jones, Jones, and Jones. Okay? With my 80 people, and I'm best friends with the judge. And I'm going to destroy him. It's going to be an event of epic proportion. People will be speaking about this for years. Or, option two, this guy must be a genius. He must be so bright and know. What does he know that I don't know? That he would have the audacity or the gall to come in and try a case. He must know something I don't know. I will tell you, 10 times out of 10, they thought the latter. What are you doing? And that fear, that much, is an advantage where I can walk in a courtroom and say, I own you. When you walk in the courtroom, will you own that room? Will you have the ability to walk in, whether you're a personable person or not, whether you're introvert or not, whether you don't like standing in front of people, whether you don't like criticism, whatever you want to list down, will you stand up and own the room? Will you stand up and be able to say that there is nothing you can ask me, nothing that I won't know the answer to? And if I don't know, I'll say I don't know, and I'll feel good about it. How do you do that? Well, the way to do it is to start with a strategy. And the strategy is I got to break down the argument into component parts and attack it from component parts. Okay, so let's start from the beginning. I've got to start with, how do I look? How do I present? How do I get from my chair to the podium? Now, I will tell you that conservative dressing always wins the day. Whenever you can, try to be as conservative as possible in the way you dress and behave. If you're a man and you have a suit, make sure your tie is right and it's not off to the side and it looks kind of crazy. You want to make sure that you are presented. If you're a woman and you're wearing a dress or you're wearing a pantsuit or whatever, make sure it's perfect, it's not wrinkly. It's because the presentation has an impact on people. When I was working for this billion-dollar company, I said, do you want to win cases? Yes. How many do you want to win? All of them? Or something less than all of them? Well, of course, we want you to win all of them. We've never won all of them before. Well, if you want then I need money and I got to go study people in every jurisdiction that you're in. I want to know what a 57-year-old bank teller from Oklahoma is going to do, just like I want to know what the tendency of somebody in Georgia is going to do. If you understand the dynamic of the way people behave, you can respond. If you don't know, you need to be antiseptic enough so that you can't hurt yourself by doing that. So it's important when you think about dress, to dress in a conservative way that you think would be elegant, that somebody would look at you and say, you're polished, you look really great. That's the way you want to be. Start with that. Then I have to figure out a way of what I do in the room. So you walk in the room like you own the room, you sit down, you have your folder. I'm sure people have gone over these 3-part folders. There's all kinds of different techniques. I could spend a whole session on the coolest 7 different folders you could have on how to use information. But let's use the 3-part folder as a foundation. So you have a 3-part folder, you have your information in there, where you unfold it out on that podium, and you're ready to go, and you've got your entire argument in that. Remember that when I'm going to get to the podium, there are certain things which I can control, and certain things which I can't. What can I control? I can control how I start the argument. I can control what I say. So your opening about who you are and who you represent is memorized. Should be memorized, should be like you're drinking water. May it please the court, my name is Scott Major. I have the privilege of representing ABC Company. In this particular matter, I have the privilege, along with Joe Smith, if you have a partner, representing so-and-so in this case. We're here on appeal from the 3rd District Court of Appeals, from the Nova Court of Appeals, from so-and-so. You know what those basic facts are. You memorize those, and you go up. That folder means nothing to you. It is merely a guide. When I go to court, folders are props. I used to tell people once I tried a case, and there was a whole bunch of documents in it. And so there were so many documents, we actually had to use another courtroom in order to store the 135,000 pages of documents we had in the case. So what I did was, in the courtroom, I wanted the jury to understand that I was on top of it and organized. So I took 40 of the boxes, and I stacked them underneath my table so they could see them, all with the identical logo set up on the left side, top left, numbered box 1 of 52, 2 of 52, 3 of 52, in perfect order, longitudinal axis to the moons, perfect. When people see that visually, what do you do when you see an organized person? What do you do when you walk into somebody's house and everything's clean? What do you do? There's a certain mentality you have immediately about that person. So, how is your body language, how is your delivery going to help you? Well, on the verbal, on the delivery, if I memorize that opening and practice it over and over again, and know what is your issue on appeal. The issue before the court is whether or not you should recognize the 4th Amendment right to such and such. That's part of your opening, because usually, with one exception I'll tell you about later, you never get interrupted. And if you understand that on top of my opening, I got to believe what is the core essence of your argument. If I asked you to tell me in a paragraph why you win, what would you tell me? If I said you had a minute, 30 seconds, what would you tell me that would capture the essence of what you're doing? Funny story, I go to the Nationals on behalf of this wonderful institution. I'm a youngster, second-year lawyers that back then didn't get to go to Nationals, but I got to go to Nationals. And we have two coaches at the time who were professors, very, 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 very famous people. And what do? We draw the national champions first round, off brief we are. That means we argue the opposite side we wrote about. In their forum, at their college, there are 1,000 people in the room. I got to argue first. Now, back then, they used to judge. They used to actually have problems that were based on the real facts of a problem that had gone through the trial court, gone to appeal, maybe gone to en banc, and you're in front of the Supreme Court, and you were arguing it before maybe the Supreme Court had actually considered it or while it was being considered. So, what happened? I get up, everybody's there for them. I've got my coach. I get up, I button my jacket, I'm ready to go. I take my folder up. I walk up and I get to about right here. And the guy says, "You lost at the trial court, didn't you?" Yes, Your Honor. But that wasn't good enough for you, was it? You had to appeal, didn't you? Yes, Your Honor. And then you lost 3 judges to none, didn't you, counsel? Yes, Your Honor. But that still wasn't good enough for you. You had to go en banc and get 12 more judges to consider your case. Isn't that true? Yes, Your Honor. And you lost 12 judges to none, didn't you? Yes. Those 12 judges are friends of mine. Are you going to come in this courtroom and tell me that my 12 friends are wrong? Your Honor, I'm going to tell you that if you want your 12 judges to rewrite the entire United States Constitution, then yes. My name is Scott Major, and I'm here on behalf of so-and-so. And we beat that team first round. When I said that, before I spoke, my coach was under the ground. I don't know this guy. I met him out in the street. Afterward, he hugged me. I was the greatest guy in the world. But because I knew that the core essence of what my point was, it didn't matter what they said, what they did. None of the coaches prepared me, Scott. When you walk up, they might stop you. Scott, all I knew was I don't have to fight them. I know where I need to be. I know how passionate about what I believe in this particular issue. And as long as I can communicate that, there is nothing that will unravel me. Have you ever been in a situation where somebody says something and you get defensive and react? How many times has that happened in your life? If you took a breath, said, can you just wait a minute, I need to go out in the hallway, do some research, think about this, and then come back and then crucify you with what... If you can figure out a way that every time somebody asked you something, you never reacted, no matter how preposterous, ridiculous, mean-spirited, demeaning, condescending, supercilious, and arrogant it was, you'd be a hero. Nothing bothers me. Nothing is the end of the world. The end of the world is not the end of the world to me. If you have that mentality, then you're going to understand that all I need to do is make sure that the people across me understand that I have a conviction and I believe in something. And for as long as you want to stand here, I'm going to talk to you. But when I get done, you're going to find for me. Why? Because I own the room. Why? Because nobody knows more than I do. And as part of this fundamental premise of walking up to the room, remember something. I don't care who's judging you, with the exception of maybe the person who wrote the problem. You will have a guarantee they will never know more than you. Ever. I tell that to everyone. I've been in front of thousands of appellate judges. No matter what you think they know, they don't know your case like you do. That's pretty powerful. If I asked you about what it's like to be a first-year law student, do you think you'd have a better way of telling me what it's like now than I would telling you as a revisionist historian from a billion years ago? Of course you would. That would be comfortable for you. You wouldn't feel intimidated if I asked you. If I asked you about your background, would you be afraid? Would you say, I don't remember what my background is? Of course not. So there are certain things which you are comfortable with. If you make this argument about something you're comfortable with, if you make the argument something where I'm going to have a conversation, the whole purpose of this oral argument, take away the word argument and throw it in the trash, because the new word for argument is conversation. Not too long ago, I was in front of a judge, and the other side was arguing, and the other side said, Judge, big, long argument, multi-party litigation, horrific, big-time things been going on and on and on. And the guy says, Judge, and Mr. Major, he can't plead this that way, and he can't do this. And the judge said, well, that's a good point, but you know what I'm going to do? I'm going to bring it up with Mr. Major when you get done. What else do you have? He goes, and it's fucking Russian, and Mr. Major, he can't do that, and he needs to take that out of his pleading. He said, that's another good point, but let me address that with him too. And sucking Russian, and he shouldn't do this, and he shouldn't do that, and da-da-da-da-da. And the judge says, well, that's a third point that I might want to address with him, but go on. And then he had a discourse with the lawyer about other things that he agreed and disagreed with. He said, Mr. Major, hi, I'm Scott Major. On behalf of myself and 2 others, I represent, 3 innocent children who were sexually molested by these horrible people over here. And let me just address your 3 points. There was concerns about point 1. If I were to agree, Judge, with you and do exactly what they said, would you have a problem with that? In fact, as to all 3 points, if I do everything that they want, will you then deny their motion? He said, I absolutely would. I said, well, thank you very much. Do you need to hear anything else from me? I had an hour and a half to argue that. Okay? But my goal was to get the motion denied. I don't have to have a fight with them when I understand what my goal is. If they had not opened the door, or if I had chosen, I'm going to fight no matter what it is, I'm going to fight, then I would lose sight of what my goal is. And we're going to talk about what your goal is in a minute. But think about, in your problem, what's your goal, depending on what side you're arguing. How do you remember where you need to get to? And this becomes an art. First it's a science, I got to go through the rules. And then it becomes an art where, come on, give me something. Give me anything. By the time I get done, you'll be back on my point. But go ahead, try it. And then they say something, you say, yeah, and then I move them back into my argument. Before they know the other person, and then I move them back into my argument. And once you get good at it, it becomes you welcome what they call hot benches. You welcome them to question you because when I'm in the appellate courts, Supreme Court, what's your problem? Sometimes I've gotten them and said, Judge, if you plan to reverse, tell me every reason you have. Don't not ask me. Please, tell me what your problems are. If there's anything I've written bad in my brief, you don't like the way I'm dressed, tell me. Because whatever they say, I'm going to make them feel comfortable that they need to go my way. So I'm not afraid of the opposition. You're not afraid of the conflict. You're not afraid if you know everything. If you go into your final exams, and I had secretly given you the essays that were going to appear on that particular civil procedure or real property exam, and you knew them beforehand, wouldn't you have a little different feeling about maybe walking into that exam? So if you were to learn just about everything there was, you'd be able to feel more comfortable about going in and doing it. So the way, in the tactical manner in which you do this, is to feel comfortable that it doesn't matter what they say, I know what I need to get across. So part of that goes into, I've gotten up now, I've made my opening, I've said where I'm at, and now I'm about to tell them why we're here, why I win. If I'm comfortable and I know that, that's good. I remember having a case, ended up going before the Supreme Court, but I had a case where this mother wanted to handle a situation she had where her baby was dying in the womb. And they said that she could abort the baby, or they said that because of the nature of this condition, she could take the baby to term. The baby would probably die. Would either be dead upon birth or close to death upon birth, but if the baby lived, it would only live minutes afterward. She could donate the organs to save 3 other children's lives. She chose to do that. And literally, during the cesarean that was occurring, in walked state attorneys and police and federal marshals and wanted to arrest the transplant team for murder, for killing what was a baby. The baby was born without a brain. Unique, unusual situation. The question was the baby alive? If I could figure out a way to make an argument to show that the baby wasn't alive, then there'd be no killing, no matter what side of the coin you were on, and then they could get a better understanding of how to do that. Very technical argument. In my opening, in front of the Supreme Court, I said, ladies and gentlemen, this case is about life. You have the awesome power today to grant life. With your decision, you will save children's lives. And I'm going to give you the legal reasons why you can do that. Now, I remember it being on the front page of every news and all this kind of stuff. And like people just like, and you could hear like in the room, there was like this, a word for him. Capturing the essence of what is your story. What is it that's going to convince people? What is it that's going to get them to understand what this issue is about? The Fourth Amendment, searches and seizures, HIPAA, person's privacy protections, exceptions to the rule. How will you humanize your issue? How will you make it where you're elegantly understated, yet when you get done, it's hard not to agree with you? How will you do that? So you need to think about thematically. What is your theme? Is this all about life? Instead of talking about why it wasn't murder. Instead of talking about why you weren't killing the person, I turned the issue on its head, and I gave them power. I don't know about you. I probably crossed 100,000 people. Never met anyone that had a problem with power. No, you know what I want? I'd rather be a servant. I don't want to have all the control over everything in my life. I'd rather you have that control. You give somebody power, you're giving them a lot. So I gave them power by recasting the issue, by changing it to a human thing. Who doesn't want to save children? Who doesn't want to give life? Please, Mr. Major, give me the legal reasons to be great. Okay? So think about when you're coming up with how you're going to argue this. How would you capture it? That would be emotional, that would make me think, you know, what's really happening here? How is this issue intimate yet expansive? How is this issue meaningful now and in the future? How is the decision they make today going to impact something positive in the future or set a good precedent? How will you show the consequences of ruling against you? Essentially, I'm saying you can do whatever you want, court, today. But if you rule against me, let me tell you the disaster that will occur. Let me tell you the nightmare that will unfortunately befall all of us. Should you unfortunately believe that aside. Even though I don't use those words, I am going to show them that. And so by doing this, I start thinking about thematically, what is my case about? And you all need to think about that. If I had time, I would tell you exactly what the theme of each side was. That's for you to find out. But think about it, how do I thematically convey whatever side I'm on? And how do I capture it? It's called the hook. Okay? Something that grabs the essence, this case is about life, that grabs somebody in such a way that they will say, wow. They will say, They will say something that will make them want to hear more from you. You ever watch some of these television shows? There's a famous guy on Fox News, and he'll say, breaking developments. When will we get back? Some of the biggest news there was, because he wants you to come back. Okay? After you heard it for the 90th time, it wears off. But for you, it's breaking news. How do you capture the essence of that? Using law wrapped around some drama. Not melodrama, but wrapped around drama. Okay? And I will tell you that you have to recognize that people are human. And you have to recognize they're going to behave. Now, understandably, I'm going to be standing behind a podium. It's not like a closing argument where I can move away from the podium. Although in most oral arguments that I'm in, I actually stand off to the side of the podium. I try to give them a chance to see me. I move. I'm a visual guy. And I believe that if I talk about 2 points, I'll go on the one side, we have this. And on the other side, we have that. Because visually, you now realize there are two different positions. If I say I have 2 points to make, it's like I'm not sure which point is which and and every time I talk about this point, I'm standing here. When I say, and then when we're dealing with the second point, da-dub, 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 and da-dub, da-dub. And if he goes back to the first point, I go, well, in answering the first point, see the conditioning? This is tactical warfare. You want to win or not? Okay? And you won't believe how you can condition even the strongest of judges. Because what I'm doing is I'm thinking about behavior, and I'm thinking about how that works. Remember, I'm starting to give you powers that now when you walk in, you're less concerned about, am I going to screw up? Am I going to say the wrong thing? Am I going to read something wrong? Are they going to ask me a question I don't know the answer to? I could give you 100 phenomenal things to be concerned about, none of which have any merit from the standpoint of the ultimate solution. Not that you're not going to be naturally nervous, not that you're not going to want to do well, but you shouldn't fear this. This is just a conversation with some people you don't know. And if you realize that I have to figure out a way to communicate and persuade people that not only I don't know, but maybe either intentionally or just arguing the other side maliciously. Think of in your personal professional life where you've tried to convince something of something that you believe is obvious, and they are stubborn as a mule, and you just can't get them off that. How do you deal with that person? If you keep banging your head against the wall and you keep screaming at them, you keep yelling at them, you don't get it. They're going to only become more defensive, more stubborn. I call it the bounty picker-upper technique. That is, you absorb what anybody says. Okay? And we're going to learn that technique in a minute. But the concept is, I've now opened, I've now wrapped around what I want, I've now taken a little theme, and now I'm going to get into my argument. And my argument has to be, what is my argument? I have 9 points to make on appeal. Probably not good. I have 2 points, I have 3 points. I like to use reasons. I like to say, there are 3 reasons why the court should reverse the decision. There are 3 reasons why the court should upheld the well-thought-out decision of the lower court. If you're upholding something, you've got to remind the court of how brilliant those people are below. If you're trying to reverse, you need to give them good reasons why it's tragic. I feel terrible about this. They must have had an off day. They're really brilliant people. They just made a small error. You got to reverse. Okay? Because in real life, you may be dealing with people that know people. But even in this environment, you want to recognize that, you can wrap yourself around the dissent here and say that it should be reversed or affirmed. You can wrap yourself around the majority. How well you do that will define how well you succeed. So I need to come up with some sort of articulable reasons. I personally like using props. And what I mean by props, that's your hands or things like that. I don't think, even though people will teach you in order to help you, they will say, stand here, don't move, look forward, things like that. And as a principal rule, it's a good training tool. But in reality, the judges will think you're rigid. So you can still be behind the podium and be conversational. You can still say there are 3 reasons why I should do something. And then what I say is reason number 1, reason number 2, and reason number 3. So I've given them, there's an expression when I used to train very sophisticated trial lawyers every year. Only lawyers that had 20 trials could go to this thing, and it was very sophisticated. And I would say, if you want people to listen, tell them. If you want them to understand, show them. So if you stimulate not only the ear, but the eye, then you're going to be more powerful. Why does our phones, why does YouTube work so great? Why is Facebook and Snapchat? Why are all these things? Because they're visual. You're stimulating more than one image. You're not just reading a text. There's something active about it. There's something you could do with that. So think about it. Visually, how can I, without being over dramatic, how can I visually tell them that I have 2 points, 1 point, 3 points? And how do I do that in a way that will let them know? Am I going to use a little body movement? Am I going to use on the one hand we have this and on the other hand we have that? How am I going to do that to visually get the cue to the person who's watching? Okay? So, 2 points, usually good. 3 if you really have compelling things, but you probably only have 10 minutes. 12 minutes, 8 minutes, small amounts of time. Maybe as much as 20 in some of the national, but it's basically short periods of time. And so I've got to figure out, how do I communicate something? I don't know you've ever been able to convince anybody of anything in 2 minutes, or 4 minutes, or 6 minutes, unless they're your friend. So you got to think long and hard about how I convince those people in 6 minutes or 4 minutes. So I have to develop, what are my 2, now I've got my theme, I develop my 2 arguments that are wrapped around that theme. How am I going to present them? The trial court erred in doing this decision because what? Because they applied the wrong law? Okay, well that's fine, but what does that mean? They applied the wrong law. They applied the wrong facts. You need to give something to, in utilizing the Smith versus Jones case, they misinterpreted what the meaning of subsection blah, blah, blah was, and should have interpreted this way. And the second point is, give some humanity to your point, right? So give some texture to what you are making as your points, so it gives some, now maybe I'm the judge, maybe I don't care about the first point, maybe I care about the second point, but if you just say because they erred on 1 and they erred on 2, I gotta wait now. Counsel, what are you wasting? What is your point? Will you make your point already? Hurry up! Or I'm gonna ask you a question immediately. Well, let's talk about this point you didn't raise. So I structure those 1 or 2 or 3 points in a way. And I will tell you that now, once I have done that, I have laid down the gauntlet. Okay? Under no circumstances will I not get to those 2 arguments. None. And the exception is none. So now I have to realize that I have a certain amount of time, and I need to hit both points without offending any of the justices by telling them I have to move on. So I have to think about what I call linkage. How do I connect in the first argument to the second argument so that as I'm flowing, I can move to the second argument, or when I get the right question, I can say, and that brings me to my second, let me answer your question, da-da-da-da, and that brings me to the second argument as part of my answer. Every answer begins with only 2 responses. Technically, there's a third, but we'll deal with the 2 responses and then a little asterisk. Every question is either yes or no. If they ask you, well, counsel, didn't this case say that? Don't say, well, looking at the case, I wanted to da-da-da-da-da-da-da, and counsel, are you trying to tell us? Well, what I'm trying to tell you is, the answer is yes or no. The asterisk is, maybe you don't know. I've had appellate arguments where the judge says something, and I say, you know, that's a good point. I'm not sure I fully thought about that. But let me give you some examples of why I think I win, and I'm moving back to my second point. Before they know it, I'm moving them back. But I'm responding. But the concept is, if you don't know, you say it. Don't try to BS the person or try to work. If you don't know, it's not always a point denier or a point deductor if you don't know. Sometimes, like I said, you're going to get some judges, they haven't even read the problem. Sometimes you're going to get some judges that think they know what something means and read it 7 minutes beforehand and are trying to be smart and they want to try to show you they're smarter than you and they ask you something. Don't be afraid of I don't know. Just remember that if I say I don't know, I need a connector. Whatever they say, when I say I don't know, I've got to work that back into my argument. Well, Judge, I don't know the answer to that, but I still don't believe that it changes the need for reversal. The judge got a problem with that, they'll say, no, wait a minute. And I've even said to the judge, like, I doesn't understand him. I'm sorry, Judge. Maybe I'm not following your question. Can you help me out? And tell me a little bit more about what your concern is so that I can respond to that. Because I really want to get I want to give you everything that you need in life. I'm there for you. Okay? There's nothing wrong with asking for that if you're confused or if they start getting argumentative with you. Okay? I'm not going to be afraid. I'm never going to be defensive, even when they're attacking. Now, as part of this, I've given the 2 reasons why, and I'm starting to connect into the body of the argument. I need to keep in mind where do I want to be. Remember that theme we talked about? How do I get them to win? Okay. And now I'm going to start to develop the body of my argument. So I've made the points, and now I need to tie in some factual context to tell the court why it is that those 2 reasons you gave are winning reasons. Why? What are the relevant facts? There's 100 schools of thought on that. Some people say, Your Honor, would you like me to give the facts? I personally believe you should never ask questions of judges, ever, unless you're responding to one of their questions. And what I mean by that is, when you make the argument, you move from the theme into the points, and then you don't even bat an eye, you go right in. The facts of this case are false. Or, I even like taking out all the extremist words, and I'll say, in 1973, such and such happened. In 1995, in 2014, Mrs. Summers, she didn't know she was pregnant. I go right into it. If they got a problem with that, they'll let you know. Otherwise, I've got a memorized set of facts. Okay? You can talk about anything, but for the next minute, I own you. If you know those facts, and you know them like you could talk to me at any time, you've now eliminated yet another variable. So know your facts. And recognize if there are weak facts, there's nothing wrong with that. You have to decide whether you want to bring that fact up that it's weak, or whether you want to save that to induce a judge to then ask you the question about that fact as you lie in wait. Okay? And there are tactical reasons for both. Okay? One of my biggest themes, one of my biggest arguments that I tell people is if you want to win any argument in life, your husband, your wife, your boyfriend, your girlfriend, your mother, your father, any argument, here is the secret. You got tape recorders on, pencils up. The secret is concede everything except what you want. Isn't it true you lost, Mr. Benjamin? Yeah. And isn't it true you lost again, Mr. Benjamin? Yeah. And isn't it true you did this? And isn't it true? And isn't it true? I must have said yes 4 times. Well, do you want your 12 friends to rewrite the Constitution? Okay. I didn't have to fight. Well, that's true, but, you know, we're on appeal, and we have a right to make an appeal, and, like, you know, bang, you're dead. Okay? So keep in mind that as part of this fluid argument, I don't need to win every argument. I don't need to defend every point. Isn't it true that the court here, that they found that there was no 4th Amendment privacy right, that there was no search and seizure, there was no... If they did, well, that's true. The judge just said that. I contend that's wrong. And I got 3 reasons why. I answer every question with a trigger tool. No, Your Honor, for 2 reasons. You can hate my guts. You got to find out what the 2 reasons are before you jump down my throat again. If I just say no and just stand there, I might get another question. If I say no and go back to my argument, so I need to think about if I've learned my 2 points, if I've learned that anything anybody asks me, there's only a certain amount of questions they can ask you. Say in this argument there's 40 different questions they could ask you. If you were to think every possible, okay, well, if I haven't answered all 40, even if they're bad answers, even if I have to concede something, I basically have controlled just about every variable in time. And if they ask me something I don't know, then I'll admit that. But the concept is to try to understand that if I concede everything, except what I want, don't you appear eminently reasonable when you say, honey, you're right? You got me on that one, you're right. With my friends, I'll say, what do they say? They're like, okay, whatever, you win. If you agree with someone, they're not going to say, well, I don't want you to agree with me. I don't want to be right. So you can recognize that the weapon, the art of concession, is one of the most powerful tools you will have in this arsenal that you call your knowledge. And so keep that in mind as we're doing it. You're going to get questions from the court. Don't be afraid of questions. Some people don't like cold benches. Other people do. I personally like inquiries because I don't really care what you have to say. And I say that tongue-in-cheek in that what I mean by that is, whatever you say, I want to answer. Please, pour your soul out to me. Tell me what your problems are. Tell me why you hate my argument. Tell me why I dress funny. Tell me anything you want to know. I don't care what it is. I'm here for you. I'm not afraid. And you know something? If you get me, I'm going to say, you got me. I still think I win, but you know what? You're right. You're absolutely right. I need to concede that you're right. I don't think, though, Your Honor, that means I lose. And let me tell you 2 reasons why. Reason 1, reason 2. Now, by the time I finish the second reason, I'm back in my argument. Okay? Every detour, you have to remember, what's the connector that brings you back into those 2 points? And you have to practice this. Have somebody ask you some questions about their life or your life or anything. And figure out a way, how do I bring them back? And don't tell them where you're going. And listening technique's good. I do a lot of motivational speaking, and I would do these all-day seminars. And I would tell people, I would say to the women and the men, here's what I want you to do tonight. I want you to go home and I want you to ask your spouse or significant other an open-ended question. Tell me what you did today. Tell me all the things you did today. I want you to try to get them not to say yes or no or one-word answer. If they do, you lose. So you must ask an open-ended question. After you ask that question, every question that comes from that has to be from their answer. Tell me how long you got. Tomorrow, you're going to come back to me with revelations. I said, you're going to learn things you didn't know. People looked at me like I had 4 eyes. They went home, and they started asking me, so tell me about your day. Oh, and I went to Publix, and I did this, and I did that. Okay, what'd you buy at Publix? You know, and all of a sudden, they said, oh, my wife and my husband thinks I listen to them now. And boy, they told me that what's really bothering me was 2 weeks ago, the kid was such and such, and you wouldn't believe, oh my God, I got so many things to do with. When you listen, it's a powerful tool. I call it the power of the ear. Listen. Okay? I can talk anybody's ear off. But I listen. I know you better than you. And therefore, I can communicate in an effective way that satiates your need while accomplishing mine. So listen to the question. What is the judge asking you? What do you think they're getting at? Doesn't matter if you're wrong. If you're wrong, they'll say, no, that's not what I'm asking. Oh, I'm sorry, Judge. You hit me. No, come at me again, because I want to solve your problem. I'm here for a conversation. I'm the answer man. I'm the answer woman. Okay? I'm here to serve your needs. For these 10 minutes, I'm yours. Make me as you will. And if you understand that and you recognize that, then your mentality will be, I don't care if I get questions. If I don't get questions, I always say if I don't get questions, it doesn't matter because I've got my 8 minutes or 10 minutes or my 6 minutes, which I know is going to turn into 10 because they're going to interrupt me. Try to make a short argument, you won't be able to do it. And then practice it and you'll realize how it just takes forever to do something that you thought takes a minute. Recite your argument and then time yourself and don't look at your timer until you get done. You go, oh my God, that took 12 minutes instead of 4. You know? And if you understand that, and if you've done any practice sessions or not, then you'll realize that the people are getting you off kilter because you're trying to memorize what you said. If I asked you about your life, you probably could tell me without discomfort. You would know what you know. If I asked you what you did today, chances are you probably know more than I do about what you did today. No matter how critical I may be, you still know more than me. So keep in mind, as you're doing this, as you're making this argument, as you're proceeding down this route, that it doesn't matter what they say. If they ask me questions, great. If they don't ask me questions, great. Now, we've talked a little bit about these arguments, and then we're going to get into some of the more specific questions and then some of the rebuttals. But if you notice, Scott's a bit dramatic. One of my biggest weapons, which will be yours now, is a word called inflection. When I say it's unbelievable, I not only get people's attention, but you focus on unbelievable. If there are things which have more meaning, emphasize them. We have on our keyboard something called bold and italic. Why do you do that? Underline. Why do we even have those keys? Because for some reason, we think something is more important than something else. So, use some of that inflection. Sometimes you can talk very soft, and you can get intimate, and you can tell people that you really need to listen to what I have to say. Because if you're not paying attention, you won't hear it. Or, I can be dramatic. Or melodramatic would be, that's lunacy! That judge is out of his mind! That's melodramatic. Anybody who tells you that you shouldn't use how you feel doesn't understand successful argument. Don't fault them. I'm sad for their ignorance. But you want to win? You're arguing against me? You need to impress me. And if you think out of the box, you'll do that. I remember when I got my first job. Right out of law school, I wanted to work at this firm, and they said, I'm sorry, we don't hire people from nowhere. We only hire Ivy League people. Ha ha, okay then. I set up an appointment with them because I said I had a new case. And I brought in my resume, and I brought in my letters of recommendation. And I got a meeting with the guy. And I'll never forget, the guy was sitting down at his desk. He said, just 1 minute. He's going through resumes like this. Trash, trash, trash. Just throwing things in the trash. And a side note, before he asked me the question is, so I'm at Nova, and I take a class, trial advocacy. Now, we all know the coolest thing in the world is if you book a class, you're the man here. Okay? So I booked a bunch of classes, but trial ad, they had the U.S. attorney from like Puerto Rico, some big, huge, famous guy. And I got lucky and got in his class, so I wanted to book his class, and I booked his class. I got the highest grade, and I said to him, will you write me a letter of recommendation? He said, sure. You write it, I'll sign it. I said, I can't write a letter of recommendation saying that I'm great. I'm not built that way. I'm passionate, I believe in what I am, I'm convicted, I'm confident. But I can't write a letter about myself. I think I'm good at what I do, but I'm just came from a humble family, we just not built that way. He said, okay, when you get around to writing something that you think will represent you, I want you to send it to me and I'll sign it. Until then, you're a wonderful student. Fast forward, about 2 weeks later, I said, okay, you want me to write a letter? To make it certain. Scott was a brilliant student. He led witnesses better than Fred Astaire. He crossed them better than Mother Teresa. Were it not for the professional basketball and golf scholarships and contracts with Nike and Adidas, he would not have been here, so I was graced with his presence at a level that no one could imagine. If you want more recommendations from me or the thousands of others who revere his very presence, please feel free to contact me and I'll give you the list. Very truly yours, this guy's name. I sent it to him in an envelope, not folded up. And when you open it up, it has a little sticker on it. And I said, you might want to touch this up a bit. Or I said, feel free to touch it up a bit. And I sent it to him. I don't hear back from the guy. Okay? 2 weeks later, in the mail, comes the envelope from God. I get the envelope. I take the envelope out. It has a sticker. Feel free to edit this if you think necessary. To my concern, Scott was a horrible student. Aside from his fits of narcolepsy and drug addiction, he probably couldn't beat his way out of a wet paper bag. I'm only writing this because I'm being paid enormous amounts of money to write this, but I highly unrecommend him. And should you need anything, I can give you the names of his doctors, jailers, and other people that might be of use for you. Please do not, in giant letters, contact me ever again. Very truly yours. And so I realized that he had gotten me, and I wrote him a note, and I said, you got me. You got me. Thanks for, you taught me a lesson or whatever you taught me or whatever. 2 weeks later, he wrote me one of the best letter recommendations I ever got in my life, signed by him. Now let's go back to this thing. So I'm the Nova guy. I'm the little guy in the Ivy Leaguers, okay? And so I go into the meeting, and I tell everyone, you want to be impressive? Package yourself. I always bring letters of recommendation. Always send them with the resume, always bring them. I don't care if it's from your mother, your sister, your lawyers, people, letters tell you about people. So the guy looks at my letters of recommendation, and he says, typical of people like you. Letters of recommendation with you. What, do you think that's going to impress me? You want to impress me? Give me a lousy letter. I said, as a matter of fact, I have one. I brought that letter. I gave it to him. He read it. After he got off the floor, he hired me. Out of the box thinking. Okay? Are you going to think in a way that's going to change the dynamic, going to change the paradigm, going to make people think a different way? So think about in your argument, no matter what question you get, it's an opportunity. For whatever reason, that person has a certain feeling. For whatever reason, that person feels a certain way, and we're going to satiate that need. So now I've gotten through those questions, and I have gotten through my argument, and I need to figure out a way to close. Now, in most competitions, they give you these time cards, okay? 2 minutes, 1 minute, stop, and there's some rules about those. They still do the time cards, okay? So you can ask for rebuttal at the beginning. If your particular rules permit you to do that, then in the opening you say, hey, please the court, my name is Scott Major on behalf of so-and-so, and we'd ask for 3 minutes for rebuttal. We'd ask for 2 minutes for rebuttal. Whatever it is, you probably don't need more than 2 minutes. 3 minutes would be the max. You probably don't need much time because you're going to be like a swordsman. You're going to get in and then you're going to get out really quickly in rebuttal. And we'll talk about that in a minute. But I've got to figure out a way how to close. So how do I close? How do I wrap this in the nice bow of this wonderful present I've wrapped up for the court? Okay? So what did you want to get across? What are you asking them to do? You asking them to reverse, affirm, reverse and remand with instructions? You asking them to change the law? What are you asking them to do? And whatever you're asking them to do, that needs to be your conclusion. It needs to mirror your opening. For those reasons, we ask the court to reverse the decision of so-and-so and do whatever it is you say. And to reinstate such and such. And to find the search and seizure impermissible. And to find the subpoena wrong. Whatever it is you want. I mentioned the time cards. When you get a stop card, because you get 2 minutes, 1 minute or whatever you get. When you get a stop card, let me tell you what that means. Stop! It doesn't mean go for a little while. It doesn't mean talk over the stop card. It means if you're in mid-syllable and that stop card comes up, this is the answer every single time. If you get a stop card and it's a question, well, Your Honor, in order to respond to that, or yes, Your Honor, for 3 reasons, I see the stop card has come up. May I have a moment or 2 minutes, or may I have a brief moment to respond to your question and conclude? I don't say to respond to your question, then ask time later on to conclude, because I ain't getting it. Unless I have a really nice person up there, which is not often, because they're testing you. So I want to make sure that if I am answering a question that I give and say, may I have an opportunity to answer your question and to conclude. Memorize that. It's like repeat command. You know, we're going to have an opportunity to answer your question and then conclude. If I'm in the middle of concluding and the stop card comes up, I see my time has expired, may I have a moment to finish my conclusion. If you're in the middle of an argument and it happens and you haven't even gotten to a conclusion, may I have an opportunity? Counsel, I think your time has expired. May I have a moment to conclude? If they say no, who cares? But what I've done is I've given myself an opportunity to buy time. And I've given all the power to them. They can either be the Wicked Witch of the West, or they can be the most wonderful human being in the world. And very few people want to harm you when they know they can. What they'll do is they'll say, yes. And once they say yes, listen, you want my question answered, buddy? You want my question answered, you're going to have to let me conclude. So I say, can I have a moment to answer the question and to conclude? You don't want my question answered? I'm not concluding. So if you create that connector, now the person has to let you conclude. I don't answer the question and ask for a conclusion, no, I not get it. If you finish early, sit down. If you're done, and you see you have 4 minutes left or 1 minute left, you know, we ask this court to reverse and remand the decision of the appellate court. Thank you. And I go and I sit down. I don't worry about having used up time. I've never heard any judge in the world ever complain, you know, Mr. Major, you were too short. If I've done 1,000 arguments, I would tell you I don't remember one where somebody said, no, that's horrible. You were much too brief and succinct. Okay? So keep in mind that as you close. If you're on the other side, you're going to be responding. So if you're the appellant, you may want to think about some tactical warfare. Do I want to anticipate what the other side's going to say and work it into my argument? As you will likely hear from the appellant, the Jones case does in fact stand for the proposition that I'm wearing a suit. However, it doesn't mean that that's the only suit in America. So I may want to, as part of my argument, wrap in my discussion that I'm going to concede something on their side. So they don't get up and say, counsel obviously didn't even mention the controlling Jones case, or the Jones case, which clearly and undefiably says, when they get up there and they're all planned for that, and you've already deflated them, it's the worst nightmare you could ever imagine if you're on the other side. I just love it. I finish, I sit down, I go, bring it to me, baby. What do you got left? I just took all the air out of your sails. You got a side engine or something? I mean, what do you got for me? Okay? So keep in mind that you may want to think about working in, if you have a bad fact, you may want to keep working it in. I mentioned earlier that bad facts, you may want to mention the fact, or you may want to wait till a judge says, well, isn't it true something? Isn't it true that, in fact, she didn't know she was pregnant? Okay. Yes, that's true. That doesn't change the decision. Or, yes, that's a true fact. But there are 4 cases which say that doesn't matter. Or the issue before us is not whether or not she knew, but whether or not it was a seizure. Whatever it is you're going to argue, the concept is that you need to think, is the fact important enough that it would be good to deflate it in your opening, in your factual discussion, because that wouldn't draw a question and they would think you're being honorable? Or is it something that, if they ask it, well, great, I'm going to use it and weave it into something. So did everybody follow that? Now I've got down on the other side, you get to sit and listen. Let me tell you something. You got 2 responsive arguments. Argument number 1, what you wrote down. Argument number 2, what they said and what you wrote down. So if you get really good at this, you'll listen to what the other side says, and you'll listen to the judge's questions. And I love love, if I'm on the opposite side, to get up and say, may I please court, my opening, whatever. Counsel raised the Jones case, and I think that's an important case to discuss. Wow, they're going to say, wow, that's cool. You were listening to the other side? And I'll say, as Judge Benjer, as you said, when you question him about that, there is a real problem with how the Jones case applies. And you're listening to me. What judge, what human being doesn't want to be told, you're great? I don't say as the brilliant brethren judge up there, I don't patronize him, but I'll say, as Judge Benjer aptly noted, the Jones case does seem to say da-da-da-da. We think that's a good reason why. See, I'm being reasonable, okay? What they don't teach you in these practice arguments is how to be a reasonable person within the context of that. Listen, I think that or if you think that they made a good argument, and you know it's coming, you get up and say, Judge Benjer brought up that contention about the Jones case, and that case could really hurt us. And we tend to agree, I tend to agree with that. I think we tend to agree with that there's some problems with that. But I don't think it changes the result for two reasons. Now you see, I've weaved them back into my fish tank. But the appellee's argument, the respondent's argument, is really a rebuttal. And if you remember that, you can tie your argument into really rebutting what they said, you're going to be successful. I will tell you on both sides, great thing to know. Great point getter. Remember a page in the record. Say, the record on page 3 shows that such and such. Always try to work in record citations, case names, in such a way that they realize you've looked at the record. You want to hit a grand slam. If somebody says something, you say, well, as a matter of fact, that's on page 4 of the record, and it actually says, or it says, like, holy cow, I have God before me. Okay? So you understand that working that in, case citations, you know it.